Hi, everybody. This is Mrs. McManus, and today I'm going to talk to you and give you some notes on bail or jail. So I'd like you to make sure that you have your packet open and that you have a writing utensil so that you can take notes in the packet as I go along the slideshow. So to begin with, what do we say when we say bail? Like, what does it mean? So bail is money or property that's posted by the defendant. So remember, the defendant is the person accused of a crime, or a surety, which we'll talk more about in a moment. And this is to guarantee that that person will appear for trial, which I just realized is misspelled, sentencing or imprisonment. And so if the defendant doesn't appear, the money or property may be forfeited. So here's the thing. When that defendant shows up for trial, they get that bail money back. It isn't kept by the courts. And so that's the thing. If you have to put up $20,000 in bail, then you are going to want to go and show up for trial to get your $20,000 back. So it's almost like a little bit of an insurance policy. Now, it has been decided through the years, through lots of Supreme Court cases, that a hearing is required to set bail, but that the defendant is entitled to counsel at that bail hearing as well. So at the federal level, here's how it works. When you are arrested, a hearing must take place within 24 hours of your arrest. And there have been lots of bail reform actions through the years. And what this means is that the court needs to ensure not only, of course, that the person comes back for trial, but that they have to protect the safety of the individuals in the community, right? So meaning if the defendant poses a threat to the community, perhaps they are dangerous, then the judge may decide to deny bail. Right. And then there are certain offenses, of course, that do not allow for bail. And these are incredibly violent crimes, crimes that potentially have the death sentence as a potential punishment, or other crimes that you might think of, such as treason or terrorism or those types of things. Those do not allow for bail. Now, how did this bail system sort of come about? It began in England, which makes sense since a lot of our law has its basis in England, right? Probably around 1000 CE. And as I've talked about before, judges would travel from place to place, right? And they would sort of go like on a circuit. And so these bail systems developed because they needed to make sure that the accused would stay before the judge arrived. And it was very well known that judges were horrible places to live, really expensive to maintain. And so what would happen is the sheriffs would actually ask other people, usually the relatives of the defendant, to serve as a surety, meaning that they would serve in place. And so what happens is if that person doesn't show up for trial, then they would actually take the surety and they would stand trial for the crime that the defendant potentially committed, which is kind of a crazy thing if you think about it, right? That you might be trying to help your brother or sister out, and then your brother and sister jump bail, and then all of a sudden you're the one who's up on trial for what the crime that they potentially have committed. So clearly it's a lot different now. And so eventually it starts to come into what's called the bail bond system. And bond is a written document indicating that the defendant or his or her sureties make sure that the presence of that defendant will be there at the criminal proceeding, and that if the defendant is not present, then the bond will be forfeited. And so there are people that they call bail bondsmen and bail bondswomen who are actually sort of hired to post bond for the defendant. So they are a third party. They may not be related at all to the defendant, but it's because the defendant needs money, and maybe their families can't afford it. Maybe they can't afford it. So they might go to the bail bondsman or bail bondswoman and say, look, I will strike a deal with you if you will put this money up for me. Now, if the defendant doesn't show up for trial, then the bond money must be given to the court. But these bail bondsmen and women will go and they will hunt down that person because they, of course, want their money back, right? So they have a vested interest in making sure that that person shows up. Now, they have, if you think about it, pretty big power over the defendants. They determine what fees they can charge, right? They might charge a percentage of what the bond is, and they also can choose who to accept as a defendant. Now, does Mass have any bail bondsmen or women? No, we don't actually anymore in the state of Massachusetts have this system. Other states do, though. So it is definitely worthy of noting. Now, how does it work in Mass? Well, when you're arrested, usually it's assumed that you can be released on your own recognizance. We're going to talk more about what that means in a moment, but that means that usually you can be released back to your home, to your family. So what typically happens is a clerk will come to the police station, which costs $40 to you, to determine if you need more or if they need more than just the promise to appear. Okay. They need to make sure that you're going to show up in court. So this is some of the things that they take into account. Okay. And these we're going to focus on for a little bit. What is the nature and circumstance of the charged offense? Is it driving under the influence? Is it rape of a child? Is it murder, right? They need to think about what the offense is, to think about whether or not you are, of course, a threat to the community. What's the potential penalty of the charged offense? Is this going to be given a life sentence if you're found guilty, or is it going to be probation and community service, right? What kind of family and ties do you have in the community? Are you married with children? And therefore you have a vested interest not to skip out on this trial, right? Do you have a mother that you take care of because she's elderly and sickly, right? So they're going to think about that as well. Then, are you employed? How long have you lived in the area? Do you have a reputation in the community? Do you have history of mental illness? Do you have history of substance abuse? Do you have a past criminal record? And that's going with the next one. Have you failed to appear at previous court dates? Because they might not want to give you bail if you have skipped out on bail 3 times before, right? Now, is there any evidence that you've tried to flee to avoid prosecution? Do you have any known aliases or any false identifications that you have gone by? Are you currently on bail for a different charge? Are there any restraining orders in effect? And are you currently on probation or parole or pending the appeal of a criminal conviction of something else? Something else that they might want to think about in determining how much the bail that they're going to set is what are your resources. So you perhaps have seen this on like a Law and Order, or, one of those types of shows. But if you have a private jet at your disposal and you are well known to be a globetrotter, then they might say, well, we would like you to give us your passport as a condition of your release if they decide to release you on your own recognizance, right, or something like that. So they take into account really lots of different things when they're trying to figure out your bail. Now, if any of these factors come into play, you're going to be required to post bail before you are released. Now, if you're brought from the police station to the court, the judge might make that decision. But sometimes the clerk actually sets the bail right in the police station. And once you post that amount, you're going to have to go back for an arraignment in court. And the judge still technically could increase the amount of your bail there as well. Now, when bail is ordered or when the judge releases you on your own recognizance, you'll be informed that if you're charged with a new offense while you're out on bail, your bail can be revoked, meaning they will take it, and you can be held for up to 60 days on that previous charge. Now, if the clerk or the district court denies your release on recognizance, meaning that you are held on bail, then you do technically have the right to file a petition for review to the superior court. So remember, that's the next court up, and where a hearing usually will be held the next business day. Now, as I've talked about before, release on recognizance means that you are released to go home without bail because circumstances suggest that you won't attempt to avoid prosecution, that you will show up for all of your hearings. Now, the defendants do have to sign an oath saying that they will appear, and these might include some certain things like restrictions on the type of people they can associate with. For example, if they are accused of assaulting somebody, then they, of course, have to stay away from that person that they're accused of assaulting, right? If they are accused of an offense against a child, then they might be ordered to stay away from a school or places where children congregate, like a daycare or a playground or something like that. Now, oftentimes, you're also required to observe a curfew, and you cannot leave the jurisdiction before trial. So let's say, you have this vacation in Florida and you say, oh, okay, well, I'm going to go on vacation. Yeah, no, you can't do that if you are released on your own recognizance or even released on bail. And you are typically released into custody of a third party. So if you are married, you might be released into the custody of your spouse. If you live with your parents or, a brother or sister, same thing. Now, sometimes what can happen is rather than, of course, being released on your own recognizance or having bail set for you, they might preventatively detain you. And so this means that you will go to jail between your arrest and between the trial. And this is potentially because you present a danger to yourself or perhaps to others, or to both if you're released pending trial. So, for example, if you are accused of murder, and this is the second time you have been accused, then they may, in fact, put you into prison to await trial. because they think that perhaps you are a danger to society. So there are some problems with this, of course, though. Some people say, well, aren't you jailing someone without the benefit of due process, right? Without the benefit of a trial? And is that truly fair? And also, doesn't this increase the cost of prisons and jails? Jails in the United States are notoriously overcrowded and underfunded. So if you're preventatively detaining somebody, then this is potentially only adding to that problem. So that is it for our screencast today. If you have any questions, please feel free to make sure to ask me during class. Thanks.